is Kalpesh Joshi, and I'm the Upper Midwest Regional Director for AAHOA. Welcome to Pitfalls of Franchise Agreement, Windows, Impact, and Transfers. I'm pleased to introduce today's speaker. Rahul Patel is a partner with Patels and Gaines here in San Antonio. He's a longtime AAHOA friend. Rahul has helped build Gaines into a law firm clients constantly seeking for the real estate litigation and property tax litigation services. Rahul was recently named to a San Antonio Business Journal 2016 40 under 40 list, outstanding lawyers list, and is currently the 2016 Man of the Year. Drew Senulis is an attorney with Patel and Gaines, focusing his practice on complex commercial real estate litigation and transactions. Drew was recently named one of the San Antonio's Sen's best lawyer. Please give him a warm AAHOA welcome to Rahul and Drew.
Thank you very much. I'm glad this room has a few more folks in here than a few minutes ago, where there's just a couple of us, so appreciate that. Well, this is a very interesting topic. We've got a tight time frame in which to cover a lot of this, so our focus here is going to be primarily a little bit twofold. Some of the things that you can negotiate before you actually enter into a franchise agreement, and then some of the things for those of you that already have a franchise agreement and haven't looked at it in ages, right, and are considering changing a brand. There's a lot of trade show booths out down there, right, with new brands, new offers, new incentives, things that you feel might be a better alternative for your property, and you don't know what the next step is or what the liabilities are. So we're going to try to go through those. We've had a lot of talks with the folks at AAHOA, and we really wanted to focus this on the items that have a lot of calls and a lot of questions that AAHOA members reach out to folks like Rachel and the AAHOA staff and say, hey, we have a problem. So what we did was kind of narrow this down to the three major topics that we hear a lot about. So, and that's going to be windows, impacts, and transfer. And you're going to hear kind of some of the things that are interchangeable about those three things, but those are the three core topics of what we're going to talk about today. So number one is windows, right? And in this instance is usually we get a call from a franchisee that says, hey, I have a franchise agreement with X, and I can get out in 2018, so I want to get out. Or I can get out in May of 2017. So here's what I want to do. Help me out. So I say, okay, well, let's look at the agreement. First thing the agreement says is you should have gave him notice 120 days ago. So now you haven't done that. I'll say, okay, well, don't worry about that. I called the guy and I let him know. I said, okay, well, let's look back at the agreement. Now we get into the meat of the document, right? So one of the things I always say is everyone, not every agreement, but many of the brands give you an option to be able to have a window, okay? A 3-year, 5-year, 7-year, 10-year. Some may not have any window options, just a flat 20-year agreement. You can't get in, you can't get out, right? That's the way the agreement reads. But if you have an agreement that has that, that's how it would look. If you have one that doesn't have one, maybe you have an opportunity to put something in there that says, hey, after 10 years, if I want to get out, it's a long commitment, let me see if I can do that. So what we look at this is, the critical part of this is it goes both ways when you get a window. It means you can get out at a certain amount of time, but that also means that the brand itself, if they are not happy with you, they have an option to get out as well, right? So if you're a franchisee, you've been late on your fees, you don't comply with what they want, you've got really low scores, well, guess what? That's probably an opportunity for them to get out because there's someone else here who's really a good operator and says, hey, that guy doesn't know what he's doing. Give me that flag and I'll do a heck of a lot better job than he will. So those are the kinds of things that you want to think about when you have a window. And one of the things we'll talk about is devil is in the details. I'm going to let Drew handle this. Drew is the one who gets to churn through these documents when he gets them, right? But what you want and how you want to effectuate that transfer or that window is going to be in your document.
Yeah, and so you'll see the asterisk there by notice, and that's because this runs through the entire presentation. And it's one of the biggest things we see is that first bullet, not missing the deadlines and know the calculation. it's so important. For every franchise agreement there might be a different way that notice is time-wise. Some will say if you can get out at 3 years if you give us 60 days notice, 90 days notice, 120 days notice. Some of them say you can't give us a notice until 2.5 years after, et cetera, et cetera. You just really have to know exactly what your contract, your agreement says. And the other thing is in negotiating early on, the not being in default. Some agreements simply say that so long as you're not in default at the time of the window to terminate, you're okay. Some actually say if you've ever been in default, you cannot exercise your option, your window. And so you need to make sure when you're going in, you read these contracts and talk about it, negotiate it with the franchise and tell them, well, we're okay as long as we're not currently in default. Because you never know. No one ever plans on being in default, but it can be a complete accident. It may not be, it's obviously not planned usually, but you need to make sure you do that. And the following instructions, this one is an important one because I talked to so-and-so on the phone from the franchise, may or may not be notice. The document will tell you. It will say who to send it to, when to send it to, where to send it to, and how to send it to. And if you miss any one of those, you may technically have not exercised your right correctly. And you don't want to be thinking, okay, I'm out at the end of 3 years. I gave notice. That comes up, and all of a sudden, no, you didn't. And so you just need to make sure you follow the instructions.
And we're going to have a few minutes at the end for some questions, so try to hang on to those. Now, this is really important, and we just had a discussion a few moments ago with someone earlier. It said, well, we can't change anything in the franchise agreement anyways. They say, we'll just sign it in amendment. We can't change the franchise agreement. We'll sign it by amendment. That's not the case. That's the regional rep or the representative trying to sell the brand, right? Trying to make sure you get the brand that you want and wants to make sure that the deal gets inked in place, right? Makes you get a commitment. Just like if you're a buyer or a seller, right? You want the earnest money, you want the thing under the contract, you'll figure out the things later. The problem is most of us get busy, right? And we don't remember to change that later. We don't look at the detail. So you absolutely have a right to discuss the agreement with the brand, and what they're going to do is that sales rep's going to say, well, I got to get my legal involved, so let's just keep moving. No, if you've got some questions and you have some things you want to do it now. That's the opportunity that you have to be able to get what you want secured. Some people will say, and now remember, then it's up to the brand. If there's a high demand that someone really, really wants to, 50 other people are going to put that Hilton in and you're asking for something ridiculous, they will say no. But Hilton, Marriott, Wyndham, Choice, all of them that we've ever worked with, lots of reasonable changes happen between us and the attorney. So the curing the default one, right? Put a provision in there that just says, look, if there is a default and as long as I reasonably cured it, I can still exercise this window, right? Because sometimes you might have a default. You might miss. There's lots of things that we miss by accident on auto pay, and all of a sudden we change a credit card, and oops, I got a notice that says I didn't pay my Time Warner cable bill, right? Doesn't mean I'm not in good standing. It just means I have an opportunity to cure that. So make sure your document says that, because if they don't want to let you out and you haven't done something, that's what they're going to do to keep you in it. Now, this is a big one, impact. We're at a AAHOA conference. Everybody wants to build a new property. Everybody wants to get a new brand. That's what we're here for, right? We're here for our lodging industry. We're here for our business. But what happens is now you have a new neighbor that either you don't really like, you don't want, or you just think it's going to hurt your business, so I don't want this neighbor. So first thing we always say is, let me see your franchise agreement. Anytime you call myself or Drew or anyone from our firm, let me see your franchise agreement, right? Start there. If you don't have anything in there about an area of protection, a name, some zone that you want, well, you've just made our job that much more difficult, right? How can we argue that you have a right to not have another property near you when you didn't negotiate that, right? Did you do any due diligence on the land you were buying? Are there any restrictions on the other parcels around you? Do you have any control over that? Did you talk to the city about how many hotels they want in this area and have some things changed? There's a lot of things you can do, but start with the document. What does it say? As far as impact areas, one of the things that a lot of people say is, well, I got a 2-mile radius. Well, what does that really mean? All it is like a little circle, right? A lot of times that circle isn't what we care about at all, right? Sometimes the left side of the interstate, no one's ever going to develop on because it's not a good area, right? You go to the right side, that's where everything's happening. So a 2 mile or 1 mile radius didn't do you any good because there's a whole side of the highway that you don't care about or no one's going to develop on. Or they can't develop. Maybe it's a floodplain or whatever, or it's already fully developed. So look at that. Talk to them. We just negotiated one with Choice this way. We drew out a map, literally pulled up Google Map, drew out a map, and they added that as an exhibit to the franchise agreement. It says, this is the area. Drew it out. There was no mile, there's no radius, there's nothing. All we did was we identified some major street marks, and then we said, this is how it's going to look, though. So here's another one where I always tell people, know your area. So if you say I'm on Interstate I-35, so I want everything, okay, west of 35, north of this, south of this is where I want my area. Well, if you hire someone like me, and you say, well, I want to build this, what do I do? Well, okay, we'll just build one on the other side of the highway. No one's stopping us from building one on the left side of the freeway because the protection says the right of the freeway. And the brands know that, right? And they're gonna try to sell another hotel, another property. That's what they do, right? So those are the types of things that you can do to get your area protected. Another thing you want to look at, right? Get a name. If you want a name, you want an area, a demarcation, Airport North, Airport South, Westheimer, whatever area you want to do it, ask for it. If you ask for it now and you ask for that protection, you say, I just want to be the only airport property here. No other airport designations here. Doesn't matter. Ask for it. If you ask for it now, there's an opportunity to have that discussion, and you can probably get it, right, before you get that hotel built or bought. And maybe they don't want to. Maybe they say, no, we're going to have 3 airport properties because it's LAX. Well, then you might not get it. But most of the things that you want to call it domain, Riverwalk, ask for it. Put it in there. Make sure you get them to agree to that before you sign the agreement. They are hungry to do the deal now. Once they've done the deal, they're already moving on to trying to do the next one, right? So before they do the deal, you have some ability to have these discussions, right? Just like when you buy a property, there's some things you don't like during the due diligence period, you bring it up. You try to get them to lower the price, right? Same thing here. You have an opportunity to discuss the things that matter to you, right? So this is where it's very important to make sure that the things that you want, get it in there before, okay? If you're about to build a property, right, or buy one, I hope you've done the homework to know why you're putting it there. So if you've done the homework of why you're putting it there, then get some language in there that protects your business from stopping someone else from coming in there and taking that market share right away, okay?
See, I told you notice would show back up. Here, just like as we talked before, if you receive that notice of application, that neighbor's coming in, here as well, you have to understand the deadlines. Can't tell you how many times we hear, well, we heard that it was going to, or we received this thing 5-6 months ago, but now it looks like they're actually going to do it. Well, I can tell you when that notice of application, they were actually going to do it. It's not just now happening. And so you have to understand the deadlines and make sure that you follow what their requirements are on the issue. The other big part here is, and we see this a lot, present your data, not your anger. Anger is never an argument. Yes, we get it. Somebody's moved, they're taking your space, whatever. That's not an argument. It's the data. It's, as he spoke about, if you negotiated it prior and you talked about your area and you can come back and say and make a data argument, it's far superior to just looking at somebody and being angry. How could you do this? I talked to so-and-so, they said it would never happen. Well, okay, who did you talk to? Well, I really don't remember who I talked to, but they were with the franchise. They said, don't worry, this will never happen. We won't build next to you. You got to present an argument. And if you can't, if you know that you can't do that, that's when you really need to start considering consulting an attorney. That's when you need to, some of our best work is not the argument, it's presenting the argument that you know you have in a manner that doesn't make the other side flare up. That's what a lot of it is.
Instructions for the dispute. Well, just like Drew said, genuinely, for us, most of the attorneys at the brands, we know them pretty well, right? Or we've had conversations with them. And what happens is when you have a level of kind of impartiality there to have a discussion about that. It comes across a lot better. Now, you are their relationship partner. We want to continue to build that and keep what you have strong. So if you're upset and you're angry with them, that only hurts your future with that brand, right? So what we want to do is make sure we get that information, put it together, and get it over to them in an articulated way. Now, we're going to talk about the instructions for the dispute a little bit further, but main thing here is if you have any issues, right, make sure you follow the instructions. Calling the guy you know and leaving him a voicemail isn't enough. Okay, so open up the agreement and see what it says. If it says you have to send a certified mail to this address, that's what you have to do. An email doesn't suffice. You can't tell you how many times we sit down with a client or we have a call with them, and they say, well, I talked to this guy on, I don't remember what day, but I talked to him. He doesn't know the name, doesn't know the full name, maybe he knows the name, doesn't know what date, doesn't know what we talked about, and we have no way to document that. So if you're going to do that, that's fine. A lot of us like phone calls. That's how we operate, right? We're relationship-based. So send up an email right afterwards. Pursuant to our conversation today, it is my understanding that you will not build this other property within 3 miles of our thing. Please respond if I'm incorrect. That's it. Now you at least have some, is that email going to be enough to hold up in court? That's a different story. But is that email at least something that your attorneys know and you have a question? If something does get ugly, can we take a deposition of you on this day? Were you not here at this day? I can do that. But I can't do it unless you have that information documented. Plus, oftentimes people have a tough time recalling when that happened, who it happened with, or that person's not even there anymore. So those are the kinds of things you want to look at. Now, transfers. We're going to spend a few slides on transfers. Permitted transfers. This one is, I was shocked that this is as much of a topic with AAHOA as it is, but after talking with Rachel, she really kind of told me where this concern is coming from. But permitted transfers, we're going to keep hitting this. Notice, notice, notice. Every one of your agreements has provisions in there that says you have to notify them of what you're doing. If not, you're in default, right? If not, you're in default. Notice, notice, notice. So I cannot stress enough how important it is to make sure wherever your notice sections are, you follow them to a T. If you have an in-house attorney, you have an in-house person that deals with it, or you have an attorney themselves, just make sure they follow with that. Now, this is an interesting one, which is death. In our Indian community, we have a tough time, I think, speaking about succession planning. What are we going to do when our parents pass on their properties to their kids? Many of us are involved in our hotels that our parents have been working and developing. We kind of take over, we get involved, but the credit rating is still with the father or the mother, and they're still the primary investors. They don't want to give it all away to their new son-in-law who might take off with it. Who knows? So they have all this kind of thinking going on, and in our culture, we never talk about it, right? Like we don't ever talk about it. We don't want to talk about it. I don't want to ask my dad, and my dad doesn't tell me about it. So we just go along our way. So what I leave you with is this thought. If you're in your 60s or 50s or 40s, whatever it is, and you're signing a franchise agreement for 20 years, think about it. Is your plan to be running that property day to day, being involved and wanting to do all of that for the next 20 years? And if it's not, and I'm not saying that it's not for everyone, but if it's not, then have that thought of what am I going to do? Who is that person? Is it going to be my son? If it's like me and I don't have any involvement in it, then I don't want to be the successor of this. It's better off being someone else. Have that discussion and make sure the brand knows this. It says, hey, look, you know, I'm 55. I'm signing a 20-year agreement with you. In about 5 years, I'm going to start passing some of this along to my son. Here's who he is. Let me put some notices in there that says I can transfer 10% or 15% or 5% a year to this person. You screen them now, and I'll pass it along as long as I stay in good standing. So try to come up with that plan. Also, your operating agreements are really becoming important. You'd be surprised, we're getting lots of calls from people who pass away. They don't have any operating documents about where this stuff goes. Some of the states have some really bad rules as to how some of this stuff transfers, or if at all. Some of them, by default, just go right back to the entity and not to whoever you thought was going to get your 5% share. Because if I'm 50% and he's 50%, and all of a sudden his 50% is supposed to go to his wife, I don't want to be in business with his wife. Him and I have a good relationship, but I don't know his wife. I don't need her in my business. So I might, so these are just some of the things you should think about that just says, you know what, I get to just buy him out. Or I don't have to pay him at all. His interest just goes away. So you really got to think about these things, okay? Especially if you're making that kind of commitment now. Sit down with your estate planning attorney, your wills and estate, and sit down with and bring your kids there. I encourage you to do that. The better you have that discussion now, the easier this is going to become. And you'll be surprised. Like I'm in my 30s. I tell my parents all the time, spend your money. Spend it all. Or whatever you're going to do, spend it. Because if you're going to give it to me, I'm just going to buy more cars with it, right? Or whatever. So you stop going to driving to 10 places to get $1 off on the milk and just spend it. But you know what? It's hard for them to do that. So I get it. But I have that conversation with them. So the death part of the permitted transfer, it's allowed. Just make sure you know who you want it to go to, how it's going to go there, and there's a path to that. Because I'll tell you this, it's like we have my in-laws have property in India, and I tell them, sell it all. It doesn't matter what you get. Because when it comes down to us at some point, it's going to go for a penny on the dollar. We get a week, maybe vacation to go there, and me showing up in India, I'm not getting any maximum value for land, right? They know. They can see me coming a mile away. So do what you want to do. Come up with a plan. Do it now while we're around and we can have this discussion.
Yeah, and so that brings us to the unpermitted transfers and what we like to call the accidental or unintended. Now, they're not truly accidental, they're not truly unintended, but I can't tell you how many times we hear, hey, I got this default notice from the brand that says we no longer have site control, facility control. What are they talking about? I've been here 20 years. But the issue is, the franchise may be in the individual's name, and then all of a sudden at a seminar they heard, hey, it's a great thing to put it into an LLC. Let's do that. Without realizing that, yes, you own 100% of that LLC, but that LLC is not who the franchise agreement is with. That is a transfer. And we see it a lot of times in purchase. We'll get a call that says, hey, we heard it's a great idea. We're about to buy this deal. By the way, we're closing tomorrow at noon. We'd love to set up an LLC. It's a little late, but you can do it. And that leads into this next one. If you talk with your franchise, they are usually more than willing to say, okay, look, we understand how it works. You found that piece of dirt, you want to build, you want to get it under contract, do it on your individual name. We don't have to wait to get the LLC set up. Or you found the hotel already built, same thing. You want to get everything in place. And they'll allow you, usually first year, 18 months, whatever you negotiate. I've seen as long as 2 years, where the franchise will say, okay, we know this property is intended to be eventually in an LLC. So there's going to be no fees. You still have to follow their processes. You have to let them know who the members are, all of that. But you've pre-negotiated. And so it becomes one of those permitted transfers where you may just have to give them notice when you finally do it. Maybe you've already walked through all the steps, but you're not in default. There's no more financial consideration you have to give in order to do it at this point. You've negotiated it into the deal. And just remember, all of your transfer documents, you can't just do it and then tell the franchise, usually. They need to approve it. They're looking for that control. Yes, we understand it's in your name, but we want to make sure you have control of the entity as well. That's what they're looking for. They're looking for that person that has control.
So here's another one, the unpermitted transfers. We deal with this probably more often than anything, all the time, every single time. And you'd be surprised, right before closing, hey, I don't have a signature from this guy, XYZ Patel. Oh, he's not part of the hotel anymore. What do you mean he's not part of the hotel? I bought him out 3 years ago, $100,000, so we don't get along. Okay, great. But he's in the operating agreement. Show me where you bought him out. I don't have that. Okay, so how can I do this without that signature? Okay, here's a document. Can you go get his signature? Oh, me and him don't talk. We don't like each other, right? We got in a fight. He's not going to sign it. He's not going to sign anything. So now I got an operating agreement that says you're still part of this company and you don't speak together. Now, how am I going to effectuate this transfer? So before you give that check to buy that partner out, get it documented. Okay, go see a lawyer. Just draft it up. It's not, you have to realize that, I tell clients all the time, if you don't want to do it now, that's fine. Just save that check, add an extra zero to it, and put it away, because in 3 years, you're going to call me with that check with the extra zero on it, because that problem of yours is going to become a big problem. Right now, it's just a couple of documents. 5, 6, 8 hours work, done. Get it over with. Later, it's going to be a whole mess, because now I got to find this guy, convince him to sign a document. He's not going to sign it, because you bought him out for $100,000 less than he put in, right? Because the property wasn't making money, or whatever the issue is. He thought you were stealing, you didn't like him, whatever that reason is. So how are you going to get that done then, when you need it to get done? Or you're going to do it incorrectly, and you're going to have another problem. So get that stuff done and get it done properly. Now, this is really an opportunity. This isn't just like Wyndham and Choice or some of the brands. Everyone, Marriott allows us. I've negotiated this on many deals. We set up, instead of an LLC, we set up a limited partnership. Every deal usually has everyone has a skill set, right? There's a couple of guys that run the project, develop it, manage it, deal with the day-to-day, and then you have someone who's like an investor, right? Puts money into the project, doesn't really want to deal with any of the headaches or the risks, doesn't even like signing documents. Maybe he's like my dad, where he's got to go to Office Depot to sign something and then fax it, and takes him 3 days to get something done. And some of us, you just get it to us, we put it up on our phone, boom, 5 minutes later you have it. So what we do is set up a structure for folks that's a little bit different. Set up a limited partnership, create a general partnership LLC. And then we say, okay, all the control is with these two guys, okay? They're going to want to make the decisions. As long as these two guys sign off, they're good with everything. And then the rest of the guys will be categorized as passive investors. And I allow myself to say I can transfer passive interest with just notice to you. And you can't really say no, as long as you run a background search on them. We just did it with Marriott. We just transferred somebody who had 7.5% interest to someone else after the fact. No questions asked. They just said, here's the documents, here's what we're going to do. We sent it over to them. They reviewed it, and they said, okay, just fill out this background search on this new person. I just want to know, make sure the person that they're bringing in is credible or whatever. They passed the search, and that's it. We had an amendment done, and it was done. So it's not like it can't be done. It's not like it's difficult, but you just have to make sure that you follow the process. That process costs you a couple $1,000s. But when you have the process, when they send you a letter and it says, hey, who's this guy, right? Why is he in this deal? Or why do I have an operating agreement signed by this guy that's there when you originally signed it with this? Now you got a problem. And that problem becomes a really big problem if they don't want you anymore, right? Like you've been in default, they don't really like the way you operate, you haven't been kept up with your PIP requirements, X, Y, Z. Well, guess what? Now they have a reason to say, guess what, buddy? You're out. You're in default, you've been in default, we don't want you anymore. We got a new guy who's ready to take this over. Now you got a big problem that costs a lot more money to fix than the first time. So whatever you want to do, I'm telling you, you can have reasonable negotiations. Now, can you say I can transfer 100% of the interest without ever asking you? No, they're not going to do that. But there are a lot of deals where you have people that are 2 or 5 or 7%, and you have to keep going back to them signatures. Set up a different structure so you don't have to go back to them every time. And if you do want to switch out or one of them wants to leave, you can do it without having to make your entire process much more difficult and take up a lot more time.
So another transfer, sale, usually a pretty good thing. The sale of the facility, almost always a transfer. I can't tell you how many times, well, we sold that property, it's not our deal anymore. Well, did you get franchise approval? Maybe they did, maybe they didn't. But the franchise agreement, important note, franchise agreement doesn't follow the facility. The franchise agreement is with you or an entity. It's not the building. It's not what we call the sticks and bricks. Yes, that is the hotel and that is what it is, but the franchise agreement follows you. So if you're the buyer, you need to make sure, and a lot of you know this, but you need to make sure you're negotiating and asking for a franchise contingency. In other words, this deal is contingent upon us getting approval as the buyer to be able to operate as, and it may be as the existing flag, it may be as a different flag, it may be whatever, but you need to make sure it's in there before you sign the deal, before you go into your feasibility period to purchase the property. As the seller, a lot of sellers will think, oh, they didn't ask for it, it means they're stuck. Hold on, because if they don't do what maybe they told you verbally, oh, don't worry about it, we'll take care of it after, we're going to terminate that flag anyway, we're going to completely rebrand this thing. Okay, is that in your document? Is there anything set aside for them to do it? Because remember, the franchise agreement is with you. And if you sell it they run it as that flag, have no permission to do it, 3, 4, 5 months. Guess who the franchise is going to look at? They're going to look at the seller. Hey, the franchise agreement, this is your agreement. And so make sure when you are negotiating that, even as the seller, that it may not be the contract's contingent on it, but you at least set out procedures and protocols for how you're going to handle either them getting approval to continue under that flag or a whole new brand or whatever the deal is. And that leads into consider the post-termination checklist matters. Like I was saying, you all know in your franchise, if you terminate, you have to do everything. You have to get rid of the sign, take it on the website, check out. You have to do all of the steps. If you sell it and you don't take care of that, it's still on you. And now all of a sudden you're going back to a hotel that you don't even have the keys to and trying to make them, what are you going to do, go take down the sign yourself? No. So you need to make sure you're walking through that in your contracts on the sale.
I mean, Drew hit those points very well. And this is really important because it's happening a lot. People are really, the transactions for buying and selling have gone up considerably. And this is this type of stuff that gets forgotten a lot of times. I sold it, I don't care anymore. But these are the types of things you want to consider. And that leads us into this next thing called the notices. We call it in our firm, we call it the lawsuit drawer. It's a internal joke for us because this happens all the time. We get someone who comes to us that says, hey, I got a letter. I'll bring it by, they'll meet me somewhere. I'll bring it by next week. Okay, that's fine. A couple weeks go by, they never come back. A month later, they come and say, I got another letter. And show up and I was like, well, that's not a letter. That's a notice of judicial foreclosure and seizure of your assets because you got sued in Georgia 5 years ago. There's a judgment against you for $1 million. They've domesticated it now to Texas, and now what they've done is attached your hotel to this judgment, and they're coming to take it. I don't think so. I sold that like 5 years ago. And this sounds funny. Literally, this is what we do, and this is why we're standing up here, because we get these. These are the types of calls we get. Like, what do you mean? You sold this 5 years ago. Yeah, I sold it. He ripped me off, I took $50,000, and I walked away, and I moved here. You don't have any documents that show that? No, the franchise agreement says you got sued. You didn't even get the letter. Did you get the letter? No, I didn't get the letter. I never got forwarded the letter. So this is talking about updating the franchise information. If you leave a partnership, get them to update the franchise information. Make that happen, okay? Don't take your check and walk away. Make that happen. That should be chip one on your negotiation table. I'm going to take a $50,000 loss. You go get me off this agreement. Make that happen somehow. Doesn't matter. Or make your attorney go get it done. Send the letter yourself to Choice. I'm out. I'm leaving this property. I've been bought out. Here's the operating agreement. These guys are now in default. Maybe your personal guarantee still stays on there, but at least you're out of this thing, and now you've got some notice there. Update your information. If you move, if you have another address, update the information. You'll be surprised how many people come to us and say, I never got it. There's no way you didn't get it. It says certified mail, return receipt requested. There's a signature from somebody. That's not mine. I don't know. Well, I don't know what to tell you. It's hard. It makes a very difficult legal argument to say we did not get notice. Now, we've come up with some creative ways to say you haven't got notice, but that's a costly argument for you, right? Profitable one for us, costly for you. So just update that information. That's free. That's easy. You can do that yourself. Another thing that I am starting to really strongly suggest to folks is get a registered agent service now, okay? You have multiple properties. You have lots of things going on. Do you trust your assistant manager at the property to make sure that all the important mail gets to you? I don't even, like, my dad checks his mail every day, right? Every day. Like, I gotta go check the mail. I'm like, what? There's nothing in the mail. Like, it's just junk, like magazine. Like, what do I need to go there today for? Like, I drive right past it, and I check it like on Thursday or Friday, you know, and it's a pile of crap, maybe one thing in there that I need. So how much of that, how much mail comes to your hotel that you don't go to for a week because you got 5 other properties? Did you check all your mail this whole week while you were out? Did anyone scan all that email to you, that mail? Do you know what's there? You know, maybe one of your brands sued you while you were out, right? Over at the AAHOA conference. Now, I think they made a rule, right? But so update that information. The registered agent service is so cheap. It's like $120 a year, something like that. And there's like an office, a company, their whole job, their whole company's only duty is when they get something to figure out a way, how do I make sure Drew gets it, right? And that way, it doesn't matter if you move. It doesn't matter if you change addresses. He's going to get it. He's going to figure out a way to get it to you. That's why you pay him $130 a year. It's cheap, super cheap. So get a registered agent and make that person be the person. What happens if, or a lot of people don't like to do that. They want to give up the control. So when you take on that responsibility, you should do that. Another thing, if you're a 5 or 10 or 15% partner, I would add yourself to the notice list. Okay? You have that right to just say, notice with a copy to me. Why? I'm 5% partner. I put in $125,000. I have the right to get a notice. How many times do you think your partner is going to get something in a late default, hasn't paid his loan payment this month, 15 days late, and doesn't give you the notice? Right? How do you know? How are you ever going to know? These are the things you really need to focus on. They're very easy to do before you sign up. And then you don't have to think about it. At least you know that I'm going to get a notice. I'm going to get a copy. I'm going to get some extra mail. You know, the system, we call it the lawsuit drawer for a reason.
Yeah, and we do. And if you want to have a lawsuit drawer, make it an actual lawsuit drawer, somewhere to keep your documents. When we say the lawsuit drawer, there seems to be a recurring theme that if I don't see it, it doesn't exist, which isn't true. It's not going away. Their attorneys do this for a living. They're not going to be like, well, he hadn't responded, so we're just going to forget about it. That's the timely advice. If you open that notice and it says, hey, we're going to do X in 30 days, believe them. They're going to do it in 30 days. Don't wait 6 months and then say, well, we did get that notice originally. It said 30 days, but we really didn't think they would move that quickly. So you seek timely advice, and whatever you do, it's beyond the scope here to say what your system and protocols need to be, but you need to have a system and protocols. And it's never a bad idea to put it in writing. Maybe you identify key people. Maybe if you're a big enough group, you have more than one person, but you have a chain of command. Everything that's legal, seems like a notice, it needs to also go to X, and make sure you have somebody with some accountability in that position to say, hey, we got the notice. It doesn't need to be, well, so-and-so's here on Thursday, so they'll do it. So-and-so's here on Wednesday. No, it needs to be one person, one system in place. And have documents. I can't tell you how many times we get that first call, that first email, hey, can you help us out? First question we ask, send us your franchise agreement. Oh, man. Yeah, we have it somewhere. I'll get it to you. Maybe we get it. Maybe we get it in Word file that's never been signed, and it says on the top, version 2. So is this the final version? Is this the version? It's not signed by anybody. So you have to make sure these are important documents. They tell you everything you can't do with that franchise. And conversely, they say everything the franchise can and can't do. You need to keep these documents. And with technology today, whether that's an actual hard file cabinet, which most of us don't have anymore, digitally stored, backup servers, whatever, you have to keep these documents. These documents are so important. And it's really hard to get into a dispute with a franchise, and the first thing you're talking to the franchise, you have no idea what the franchise agreement says on that issue. It's a hard argument. We don't know what it says. So make sure you're keeping your documents.
Do we have time for questions? Is anyone in charge? Do you know? Does anybody have any questions? Sure. So it looks like you have a particular question. So that's when a lot of this is happening lately, right? The franchises are kind of merging, they're acquiring one another. So what first thing is go back to the document to find out if they have the ability to sign that contract to someone else. Just like you need the right to sign that contract to someone else, so do they. And then what does that mean? Does that allow you now to have an opportunity to renegotiate that, to terminate that? Or does that say they can just assign it and they can make changes if they want to? So a lot of those, you have to look at your specific agreement and then kind of where you are in the process. What I would tell you is that a lot of times, not that they don't respond to you or want to respond to you, they're busy with a lot of other things. But when you have an attorney that gets involved and sends a letter to their attorney, they are under obligation to respond back to you, right? So that, if you've been having 2 years that you haven't heard back, it's probably time that you give them one more call or you get an attorney to send them a letter and say, here's what I want to do. Here's the changes I want to make. I want to get an agreement in place. They want that too. So sometimes those are the kinds of things that you have to do to make sure you get that process moving.
I wanted to add on to your registered agent comment.
Sure.
I think a lot of people go to India for months, and they leave a GM or a manager in charge of their properties, and that address is probably your registered address when you created that entity. And so it's really important that you have a service, because your GM may not either speak English well or know how to fax or scan something to you while you're in India. You might not be checking your email while you're in India, and there needs to be a way that they can call you, and they need to be checking that email, that if it's CT Corp or another type of agency, you need to make sure that you give them access to that email account that gets those lawsuits, because it's not an excuse when you get a default judgment against you. It's not an excuse that you left that property and that you didn't get that mail because you were in India.
Where mutual windows to terminate, for example, 5th year, 10th year,
Sure.
15th year, and it says for any reason without cause. Does that truly mean without cause, for any reason?
If the document says that, then I think that that's what you should be entitled to. Now, the thing about the law is there's an interpretation of what it says, right? So if there's a portion of that sentence that follows that says if not for any reason, but, however, provided the franchisee has never been such and such, that could be, somehow contingent upon something. The other thing is, just like a contract can say anything, but then sometimes if there's a dispute, you actually have to hire somebody to enforce that. I believe you need to do this. We agree, but now I think that there's a difference of interpretation. So I think that there is. Windows are they're there for a reason. But again, most of the time, those windows are not just absolute. They're usually contingent on them and you having a successful relationship throughout. And that, I think, is the biggest reason why people are unhappy. The biggest thing we see is they have a window coming up. The franchisee knows it. They just think it's generally like in May or June. And what they do is they say, man, these guys suck. They're not giving me any contribution. I'm going to stop paying them. Like, I'm not paying them their royalty fees. Let them collect them at the end. And then they're like, okay, I want to get out. Well, now you've been in default, and now you can't get out. Right? So you just screwed up exactly what you wanted to do, what you wanted to accomplish by not being able to do that. Sorry.
Thank you very much. Thank you for the great knowledge. And from the AAHOA, we just wanted to say thank you, both of you. And then